Morning people, welcome back to F Politics. It's been one of those weeks where the script appears to have been written by a toddler on an acid trip. David Cameron's back, Suella Braverman's gone. Esther McVey is the Minister of Common Sense. Well, today, the government's flagship policy for stopping the boats by telling asylum seekers that if they come here without permission, they'll be shipped off to Rwanda, the Supreme Court just declared that policy unlawful. Now, the Court of Appeal had already called the Rwanda policy unlawful on the grounds that it wasn't safe to send refugees to Rwanda because it wasn't safe there or because they might be sent back to their home country, which again wouldn't be safe for them. That's this thing called refoulement, sending refugees back to where they came from. But the government appealed this decision, hence why the Supreme Court is looking at it today. Now there's lots to discuss in terms of the morality of that policy to begin with. For example, the principle that if asylum seekers pass through several safe countries in order to get to us, we don't consider them to be real refugees. Because by that logic, we would only ever accept refugees from the Middle East if the entirety of Europe was an all-out war. Because apparently the geography of us being an island in the middle of the North Sea means we have no moral responsibility to the Middle East, even though we arm the conflicts there. We could talk about the morality and the colonialism of us using African countries as a bin for the people that we don't want, as some kind of political Viagra for those who like the idea of sending foreigners back to Africa. But I want to talk about the statement the Supreme Court made to explain their decision. For example, even though the judge said the court's decision is not political, he's clearly aware of the politics around this case. Namely that several Tories, including Suella Braverman, have been pushing this idea that the only thing stopping us from sending refugees to Rwanda is the European Convention on Human Rights, and also the Refugee Convention. And that if this case doesn't go their way, they can just leave the ECHR. So he was like, yeah, no.
This legal principle of non-refoulement is laid down in the United Nations Refugee Convention. There are also provisions which have the same effect in other treaties to which the UK is a party. The UN Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment, the UN International Covenant on Civil and Political Rights, and the European Convention on Human Rights. It is therefore not only the European Convention on Human Rights which is relevant to this case, as is sometimes thought.
The as is sometimes thought is delicious. The sheer shade. Mwah! He's basically saying, you motherfuckers have been lying to people. He also points out that several of our own British laws make it clear you're not allowed to send refugees to countries where they might be then sent back to their original countries where they're not safe.
They include the Asylum and Immigration Appeals Act of 1993, the Nationality, Immigration and Asylum Act of 2002, and the Asylum and Immigration Treatment of Claimants, etc. Act of 2004, the Human Rights Act of 1998, which gives effect to the European Convention on Human Rights. Again, contrary to what is sometimes thought, the Human Rights Act is not the only relevant legislation.
The shade. So, here's what this case had to decide.
The test is whether there are substantial grounds for believing that asylum seekers who are sent to Rwanda will be at real risk of ill treatment as a consequence of refoulement.
He then points out that because, according to the United Nations, Rwanda's asylum processing system is crap.
Genuine claims are liable to be wrongly refused, and when claims are refused, Rwanda is entitled, under the memorandum, to expel the claimants to any country where they have a right to reside. The only country where most people have a right to reside is their country of origin.
Translation, Rwanda is likely to send real refugees back to the countries they were trying to flee, i.e., breaking the rule against non-refoulement.
Thirdly, Rwanda's practice of refoulement, of which UNHCR gave over 100 examples. It has also produced evidence of Rwanda's failure to comply with a similar agreement which it entered into with Israel. And it raises a serious question as to whether the undertakings given by Rwanda under its agreement with the UK government can be relied on.
He also points out that the UK government has been consistently acting like Rwanda is not a safe country for years.
British police have had to warn Rwandan nationals living in the UK of credible plans by the Rwandan government to kill them. In 2021, the UK government criticised the Rwandan government for extrajudicial killings, deaths in custody, enforced disappearances, and torture.
Or the fact that there was a genocide in Rwanda within the last 30 years, or the fact that they have a recent history of shooting refugees who demand to be fed properly.
The Home Secretary's appeal is therefore dismissed.
So it's clear, Suella Braverman, the Tories, were trying to send refugees, the most desperate and vulnerable people on the planet, to a country that it is not safe to send refugees according to international law and now our Supreme Court. And yet this was Suella Braverman in Rwanda a few months ago, laughing. So them not being able to do this policy is good news, but we should all be concerned about what the government does next instead.
And if it becomes clear that our domestic legal frameworks or international conventions are still frustrating plans at that point, I am prepared to change our laws and revisit those international relationships. The British people expect us to do whatever it takes.
But hey, £140 million wasted, £1.3 million on legal fees fighting this case. Also, the Tories can show their voters how much they hate refugees during a cost of living crisis. I'm Femi, this has been F Politics, have a great week.